Module 4 of the Army's Sexual Assault Refresher Training is Sexual Assault. I'm Lawrence, I'm a Sexual Assault Response Coordinator, and my disclaimer is in the video description below. This is the first panel in Module 4 Sexual Assault. Sexual assault is intentional sexual contact characterized by the use of force, threats, intimidation, abuse of authority, or when the victim does not or cannot consent. Guidelines apply 24/7 on or off installation. Consent is the freely given agreement to the conduct at issue by a competent person. Let's unpack that a little. The way I like to think of it is consent is something you need to obtain and maintain. So obviously if someone says no, either verbally or with their nonverbal communication, you do not have consent. Also, there are times when there's use of force or the threat of force or placing a victim in fear where they may not be able to say no or resist, and that also does not mean that they consent. You need to get consent for every hookup. So if you're married, dating, have a kid together, doesn't matter. If they're dressed provocatively, doesn't matter. You must get consent every time for every encounter. A sleeping, unconscious, or incompetent person cannot consent. Sexual assault is a criminal offense. It can be prosecuted under civilian court jurisdiction or under the Uniform Code of Military Justice. Every single issue has its own facts that need consideration when reviewed by competent authority. The next panel in Module 4 is alcohol and consent. Sometimes people are unable to consent because of excessive alcohol use or drug impairment. In that case, you should know, or if you know or reasonably should know that they cannot consent, you do not have consent. A good rule of thumb, and this is from the UCMJ, is if the person can't describe what's going to happen, if they can't say yes because they're too inebriated or they can't say no because of other factors, then you do not have consent. The rule for alcohol is not if you're drunk, you can't consent. The rule with alcohol is if you're substantially incapacitated, you cannot consent. That's dangerous because if you don't know the person well enough, it's really hard to discern, are they substantially incapacitated or not. When it comes to alcohol, every fact pattern is different. There's no rule of thumb of a set amount of alcohol consumed or a set BAC renders you substantially incapacitated and unable to consent. That being said, it's foreseeable that two people could be drunk and have a consensual sexual encounter. Every case is different. Every person's alcohol tolerance and every fact for every situation is different. The next panel for sexual assault is reporting. There's still two kinds of reports, restricted reporting and unrestricted reporting. We do have some big changes that we're going to cover in this module though. There are two kinds of reporting, restricted reporting and unrestricted reporting. We're going to start with things they have in common, hit where they differ, and then talk about who can receive each report. Things they have in common. With a restricted or unrestricted report, the victim is still entitled to receive a sexual assault forensic exam if there's evidence to collect. They have access to any medical care they're entitled to. Both reports give access to a SARC or VA for advocacy, as well as a special victims counsel who's that victim's attorney representing them and advising them during the military justice process. Things that unrestricted reporting have that restricted reporting does not have is command support for expedited transfers and protective orders, and the potential to get military justice. This has gotten a little more complicated because there's a change where now a chain of command can know about a sexual assault and that victim can still make a restricted report. Commanders are still required to contact CID if they know about a sexual assault. But as long as the victim does not already make an unrestricted report, as long as the victim does not tell law enforcement directly, and as long as law enforcement is not already investigating that sex assault, that victim can still make a restricted report. With a restricted report, victims have a greater say in who knows about their case. With an unrestricted report, 6 hours after the command is notified of that report, the brigade commander has to document in writing whether a military protective order is appropriate, and if so, when it was put in place. A victim can make a restricted report with a SARC, a victim advocate, or with a healthcare provider that will refer them to the SARC or victim advocate. With an unrestricted report, you can make the report with the SARC, the VA, healthcare provider, chain of command, IG, provost, or CID. The last panel for sexual assault is expedited transfers. For active military or AGR personnel, this will be 4187 done through the SARC to request the victim move to another location. Victims of sexual assault who make an unrestricted report can request a transfer from their unit. They can request to go to another company in the battalion, another battalion on the installation, another installation. For MDA National Guard and TPU Army Reserve, the SARC or VA can also work with the chain of command to get that victim drilling on an off weekend or transfer to another unit expeditiously. If you know anyone who would benefit from this content, consider hitting the share button below and sending it to them through text message or email.